welcome back. This is Newsfile. It's your most authoritative news analysis platform, and here on Newsfile, we put Ghana first. Let me share some of your messages. Then we proceed with the next installment of the matters we are discussing for you, and that's about bail. So related, whether the EOCO is just being, lawless in the amounts of bail that it is giving. Okay. This one says that your plaintiff sigh when you uttered the phrase, this country, quote unquote, this country was not lost on me. I felt the same way too about the legal and justice machinery at work in this country. I also wonder, like the lady lawyer, whether things will change. Dr. Arthur Kennedy spoke incisively and insightfully about the issue, but I wonder what will change. Great programming. I'm following with rapt attention. Thank you very much. And then, those of you commenting on Samson's stake, I'm not reading about Samson's stake. This one, Mr. Edu says that until we are ready to hold our presidents accountable, we can't fight corruption. Are we trying to say ex-president Akufo-Addo had no idea of the gargantuan corruption that happened under him? In any serious country, the buck stops with the president. The person who needs to be interrogated by the investigation agencies is the president, as in Akufo-Addo. The immunity clause should be reviewed now, or else forget about fighting corruption. Imagine an ex-president who has run the country bankrupt and enjoys full motorcades, full security, and all other full benefits of the state. This is a huge joke. We are not a serious country fighting corruption. Okay, maybe we should go and learn from Brazil and other places. They put ex-presidents in jail. Question for Sami. In April, the special prosecutor told us that the reason why Ken needs to attend their office in person is because their investigations have yielded enough evidence for him to be charged. How come it still took them 7 months to charge him? Okay, that's from Kojo. Albert says that a number of issues he raises, but I can read only a couple. He says, if he has nothing to hide, one of the panelists made the point. We are dealing with white-collar criminals who are very smart. Now the charges have been filed. His lawyers were shouting he had not been charged. Frank Davis, right? Now he has been charged. They should produce him, get him bail, and let him face trial. You cannot put impediments in the way of the OSP and accuse the OSP. They should produce Ken now. Double standards, all trickery and needless technical effusions from those blaming the OSP now. He has been charged. He has constructive notice. He should come. He should come. It's as simple as that. Let's not simplify what challenges the OSP is facing. On hindsight, it is easy to criticize the OSP. Don't forget, the man had lawyers who were making the OSP work difficult. Ofori-Atta should just come and face trial. I read a couple more of your messages. Manche Bruce says the OSP appears to be undertaking a political witch hunt rather than objective prosecution. His handling of almost all the cases before him has been nothing short of a malicious prosecution and a florid pursuit of fantasy. Hey, for the OSP, you are guilty until proven innocent. His modus operandi have been to be playing on the emotional keyboards of the public. His flagrant abuse of the mugshots of accused persons is unfair. How does he expect to pull through with 78 counts against Ofori-Atta and others? Amazing conviction. Manche Bruce. Takrade. Thank you, Manche Bruce. Papa Bisu. Papa Bisu always says what? Sphincters Road or Sphincters. Says, I believe it is high time we found some ways and means in bringing down Ken Ofori-Atta. Sad to say, with him out there, huge sums of alleged looted state monies via him and his cronies at Setting Island and other countries. Seriously speaking, some covering up by him, will lead to Ghana becoming a bigger loser relative to hardship and sorrow he brought on us via his role as a former finance minister. Okay, thanks for your message. Yakubu Ibn Chambers says that, oh, your long message is so. Do you know why the thievery and rot in the Ghanaian system continues to fester like a virus attack on the human immune system? It is because the perpetrators of these unforgivable financial malfeasance know in their hearts that they will enjoy the best legal brains to thwart any prosecution in the future. I suggest this country adopts the realist approach to prosecuting wrongdoing, where the law is put aside and real-time evidence is applied to prosecute. The delayed tactics in financial recovery and prosecutions are nauseatingly painstaking. Yakubu Ibn Chambers sends that from Wale Wale. And the final one says, I laugh when Mr. Atta Kennedy said that, Dr. Atta Kennedy said that wouldn't have done anything to this Ken's causes, looking at what he went through at Honorable Ken's hands. Ask when Dr. Baumia was in charge of the economy, what happened? And when they sabotaged Dr. Baumia, what were the results? Gamel. Okay, I don't really get your message, but that's fine. Thank you very much. Now, let's move on to the next issue about bail and EOCO. It appears that they are being accused. Okay, so accused. All of them are being accused. So let's listen to the EOCO boss, Raymond Archer, former investigative journalist, on whether or not their bail is intended to keep people in jail.
I think some of the lawyers think that we have disrupted the bail system. And I will explain my philosophy to you. And it's very simple. I consider bail and sureties, or I liken it to the collateral you give for a loan. When you give a collateral that is less than the loan you take, there's no motivation to pay back. You can let the loan go run its length, and then there's no collateral to fall back, and you go into default. In the same way, bail is connected to a case. So imagine if I have a case of 100 million, the exposure or the risk. We do a lot of investigation for the banks, for example, where somebody has stolen $90 million. And then you catch the suspect, then you give him a bail of $20 million. Now, like I told you, assume at every point that every criminal is at least above average income. The fact that he beat the banking compliance and everybody to steal that money tells you he's not your average Joe.
So, as you know, some of the people who have been charged for millions of financial, mismanagement or corruption. For example, Kwabena Edu-Boaheng in the National Signals Bureau's case, he was a former boss. The bail sum giving him was 80 million with two sureties. Alhaji Abdul Wahab of the NAFCO, 50 million. Bernard Enchibwe-Siako, the chairman, Wuntumi, 50 million. You had Charles Mensah, is in Niyama, Chatawale, he had 5 million, two sureties. Almost all the cases, they are looking for two sureties. Edwin Provençal, former boss, he 30 million, two sureties. And then you had the NSS, heads who were also arrested. And the courts are now reducing the bail sums for those who were not able to fulfill them. Some spent 2 weeks in jail, in custody, some spent less, because it's difficult to come up with the fulfilling the conditions. Yes, Hassan. Why are you guys, even in Parliament, you are raising this issue that bail is being used as punishment?
Yes, I think that this matter again has been discussed on this same platform before. And the overwhelming view is that it appears that bail is now more or less being weaponized, being used as a weapon to oppress, suspects or persons of interest, with some very onerous bail terms and conditions. And I think that there has to be some kind of, realignment and regulated environment as far as bail is concerned. It has never been like this before until just recently. And if you have observed, there are different agencies handling this kind of cases. You have the OSP, you have the EOCO, you have the NIB, and I think the CID as well. Most of the furore and indignation is directed at mostly EOCO. OSP, you will hardly find any instance where OSP will insist that somebody must be held in custody. And not many people have gone to OSP, except maybe one or two that you hear about them in the public, especially with the exception of maybe Paul Adumochi because of who he is. And even that one, the bail conditions were not such onerous bail conditions. Now, what happened to self-recognizance bail? We're in this country for the 8 years that MPP was in power. Can you mention one person who was held in custody because he couldn't meet any bail conditions? Can you mention one?
You may not know.
You see, we have had Stephen Opuni, Seydou Agongo, Dr. Kobnat Dufour Jr., they have various chief directors, they have business persons. They were all released on bail right from the beginning. Second, you have another group, Dr. Tuforsin, Dr. Kobnat Dufour Sr. himself, Alhaji Collins Dauda, Kweku Ajima Mensah, and all of that. They were granted self-recognizance bail. Then you have another category.
By police or by court?
By the court.
So we're talking about the police bail first.
Even at that level.
We're not talking about court bail.
Even at that level. You will never hear it. Richard Jakpa, for instance, was he ever detained? He never slept in custody for 1 day.
Do you know that for sure?
I am telling you for a fact. So all these things about, we need to tie bail to the sums that, apparently had been lost and so on and so forth. But there are people who have been held in custody unrelated to any loss of money. So why are you still holding them in custody? What are you trying to recover from them? In the particular case of EOCO, if you go to their functions, Section 3, it provides that the EOCO would recover proceeds of crime, for instance. So in the mind of the executive director, if from their investigation, you are deemed to have caused or misappropriated 60 million cedis, then he has to give you bail conditions amounting to about 60 or so million cedis. That is wrong. And I think that the application of bail should be regulated under Article 296 of the Constitution because it's an exercise of discretion.
What Raymond said? He said
his philosophy.
What's wrong with that?
Yeah, he said his philosophy. Now, there are people who have occupied that office before him.
Is that philosophy compliant with the law?
It is not.
Why?
It is not. Look, we should be guided by the provisions of Section 96, for instance.
Yes, what does Section 96 say?
It provides...
What does Section 96 say should be how to deal with bail?
I mean, it talks about bail not being excessive. That one is very clear. And if you have it, we can read Section 96 copiously for the benefit of the listeners. You see, bail is being used as a weapon to oppress even accused person. Look, if you have a very solid case,
the law says you grant the bail depending on the circumstances of the case, but you shouldn't use the bail as punishment. It shouldn't be excessive.
That is what we are seeing.
Who determines that it is excessive or it is being...
At the point of inquiry, it is the agency that is doing the investigation that must exercise that discretion.
Right.
And it's a discretion that must be exercised, that they must exercise with, a lot of, empathy. But it appears that the whole idea is to convict you even before. We want to hold you in custody even before the trial starts. That is the whole intention. And I think that it is very wrong. Look, it has to be regulated by Article 296. But when you are exercising discretion, it must not be capricious, it must not be whimsical, and so on and so forth. But that is what we are seeing. Because the ED, for instance, when you heard, he said that his philosophy, so that makes it, capricious. And because people have occupied that office before, and we haven't seen some of these things before. It's the same law that we are applying, it's just different individuals. So he brings different philosophy to the office, and I think that it has to be regulated. It is, look, BNI, for instance, has investigated a whole lot of people. You will hardly hear anybody, maybe because he's a media person, coming from the media stock, because almost every case of EOCO is in the media space, especially if it has to do with any politically exposed person. So we have to be, as a country, watch it the way that we do. Otherwise, one day somebody will need Kotoka International Airport as surety. You need a property, maybe Tema Harbour. Because the rate at which we are going, 800 million, 150 million, 100 million. I mean, how many people have that kind of properties? You say for to be justified. So that means that one person amongst them should be able to bring not less than 25 million. I mean, why are they going to get these kind of properties? They are not realistic. So we must be measured, in the kind of bill conditions that. Look, for instance, if you look at Bost, Edwin Provençal, he was given a bill terms of 60 million Ghana cedis. The court reduces to 30 million. EOCO is appealing. What are you appealing for? What is it? What is it you're appealing for? And then, to make the matters worse, when the court varied the bill conditions, EOCO continued to hold him in custody pending appeal. That is wrong. That is completely wrong. You release the person.
They had met the bail conditions.
They gave it 30 million cedi, and they satisfied the bill conditions.
And they were still holding him.
And they held him because they are appealing.
Are you sure about that?
The individual's rights.
Are you sure about what you just said?
Of course, that is what I have been told.
Okay, so
that's what I've been told.
So
and his lawyer is one Charles
those who are involved
also.
in this case, and
so
maybe
please,
EOCO officials, if you are listening, we want to know. We want to check this.
Yes, I stand corrected.
We cannot immediately, independently verify what he's saying. That even after the court granted, varied the bail terms from 60 to 30 million.
That is what I read.
He fulfilled the conditions. He was still kept in custody because EOCO was appealing the decision. We would like to know about that.
Yes, so I stand
in custody. He's not in custody now.
Now I don't know.
So, but EOCO is still appealing.
Yes, I don't know whether he's still in custody.
No, he's not.
That's what I'm saying. I'm not aware, but I read, that he has met the bail condition.
My question is that if he was being held because they were going to appeal.
Yes.
Then because there is an appeal, the appeal has not been determined, so he should still be in custody.
That's what I'm saying. I don't know whether he's still in custody or not. But the point I'm making is that, and I've been involved in arranging bail for some.
How much is involved in his case?
In his case, I think it's about $5 million.
So how do you describe 60 million Ghana cedis as excessive or punishment for a case of about $5 million?
You see, you are presuming that the person is already guilty. That is the wrong thing I'm saying. You are based on Article 19, 3C or so. Correct me if I'm wrong. A person is presumed innocent until he is proven guilty or he himself admits to his guilt. But you are assuming that once you have been accused of embezzling $5 million, then you have stolen that money. And the only reason why
Theophilus is holding Act 30.
The only reason why we will grant you bail.
He had invited you earlier to read.
The only reason
96.
why.
Hold on.
Yes.
Section 96.
I have Section 96.
Please read to our hearing.
So,
a court shall not, and it is
which part of
mutatis mutandis applicable
96?
To Section 96. 5.
4
rather. Yes. A court shall not withhold or withdraw bail merely as a punishment. And 5. A court shall refuse to grant bail if it is satisfied that the defendant may not appear to stand trial. That is one. Or 2, may interfere with a witness or the evidence or in any way hamper police investigations. C, may commit a further offense when on bail. D, is charged with an offense punishable by imprisonment exceeding 6 months, which is alleged to have been committed while the defendant was on bail. None of these conditions.
But why did you? This is not conditions. This is the refusal part.
This is the refusal, and I'm saying that
you jumped how to measure the bail.
Oh, but I think I've read it.
You jumped. You stopped. You started from shall not. How is bail determined?
Oh, the amount and this is C. This is 96.3. The amount and conditions of bail shall be fixed with due regard to the circumstances of the case and shall not be excessive or harsh.
So that's the question.
With due regard to the circumstances of the case.
Thank you.
What does that mean? Does it mean that the
gravity of the case?
Exactly.
So if you are facing a charge of $5 million US dollars, translates into how much in Ghana cedis?
That's almost about 60 million cedis.
And you are asked to post a bail of 60 million Ghana cedis.
Yes.
How do you say that's excessive?
I'm saying that if you use the amounts to determine the bail, then you are more or less convicting the person.
But that's what the courts do.
No, the courts don't normally do. Why do they?
They do.
Okay, so why do they give self-recognizance?
Ask any judge. They will tell you that they use.
So what is the criteria for
the gravity of the offense?
This same law.
The bail.
This same law provides for self-recognizance in spite of this.
It's discretionary.
So it's discretionary. That's what I'm saying. So you can't say that because the amount is this, the bill should be necessarily tied to the amount. Then why do we give this in the self-recognizance bill?
In the NSS case.
What is the intention?
In the NSS case, you are talking about 2.2 billion, right?
Correct.
And they are granting bail to the tune of how much?
800 million and even 10 million.
Yes, 10 million.
For gift to a worry is 10 million.
Yeah.
And for the OCICB,
for a case
800 million.
2.2 billion.
You understand? No, but they are charged for different,
I get that. I get that.
Amounts.
How do you determine excessiveness?
Precisely.
When you use the amount. That's what Raymond is asking.
No, I'm saying, for instance, let's use gift to a worry's case, for instance. How much is Seashell to have embezzled? 30 million or is it 40 million? But the bail condition is 10 million. Now, OCICB is said to have embezzled about 1.2 billion Ghana cedis, but the bail condition is 800 million. So why would the court, for instance, reduce the bail terms from 60 million to 30 million for Edwin Provincial? Because it is not necessarily tied. It is about whether the person would appear.
Do you agree?
To stand trial.
Theophilus, do you agree?
No,
more importantly.
I don't agree. There is one part of in fact, he jumped nicely in the 96.2, which says that where a police officer or a district court has given a bail condition, a circuit court or a high court can reduce it. And that they could have done easily. I don't see where he's taking this from. What Raymond Acha said is, assuming the issue you are contending with is $5 million, as you said, and you give somebody the bail sum of 5 million Ghana cedis or 10 million Ghana cedis, and the person decides that, yeah, I'm really guilty, let me abscond, and my surety, they can pay the 10 million and I keep whatever million I have. That is some of the things that go into grant of bail. Senior, as you said, we have had this discussion before. If a police officer, EOCO, or whichever body has given bail, and you feel that it's excessive or onerous as it is, you apply to the court, the high court, as they've done in Provençal's case, to get it reduced. Even when the courts themselves give bail and you feel that it's excessive, you sometimes apply to the court to get it reduced. The idea that it's excessive, we cannot really say, except they tell you that we are going to use the bail as punishment to hold you. They don't. And again, let's educate our people. I am getting the impression you mean that when they ask you to bail condition of 50 million, it is like you have to pay the 50 million. No, you are not to pay the 50 million. So asking whether...
That is the philosophy behind
it. No, that is not. You are not supposed to pay 50 million. Is the situation where the sureties will guarantee that they will bring you to court. The whole purpose of bail is to bring somebody to court. to appear before court.
No, but the sureties.
Yes, the sureties.
They are supposed to show property worth.
Yes.
Worth the amount.
Sina, I don't know whether you've heard that when a certain judge, she's now in the Court of Appeal, she says unless she specifies the type of surety, she's not asking even for landed property. So you could go on to challenge or ask whether they really needed landed property in terms of the sureties. It could be to guarantee just by posting affidavit of surety to show that you are ready to, when the person absconds or is not ready to appear before court.
No, we know that.
Yes.
Once the decision is that the surety is to be justified,
yes,
then you really will need the property worth that value.
Yes. Senior,
and this is the circumstance you are fighting.
Senior, you see,
and he's telling you that to the extent that the court is looking at it with a different view, you give 60 million and the court casts it to 30 million, it shows that you are being excessive.
No. Senior, the courts themselves can give 60 and you go back to the same judge. Look at the Asibe case. They went back to the judge and the judge reduced it. It doesn't mean that the judge himself realized that what they have given is excessive. If the judge realizes that they are excessive, they reduce it. It doesn't mean it is somebody who has influenced the judge or using it as punishment. It is that you look at the circumstances. You go back. We do it always. Bail conditions are given even by the court. You go back to say, even that day, you tell my lord, my lady, that looking at the circumstances, my lady, this particular type of bail is as if you have refused the bail. Our application for bail. So, my lady, kindly reduce it or look into it and give us something that we can be able to
He's saying that some of these people, almost all of these people, please hold on, almost all of these people, they are public figures. All right? Why don't you exercise the discretion to grant them self-recognizance, where they only come and then they show you their ID card, and that's enough. Then you let them go. Or perhaps even just, detain their passports.
Yes, something. You use the word discretionary. The person who exercises that discretion would have had the privilege of having certain information that yourself, myself, don't have. That is in the wisdom of that person and using that discretion. This is what I'll give to make sure that you appear before us or you appear before a court of competent jurisdiction the next time you are asked to come. We have had a situation we just discussed this morning where people have absconded. So there is history. At least certain things inordinately or inarticulately would have been at the mind of somebody exercising discretion. It is not, Senior, the idea that is excessive is neither here nor there. If it is excessive, we have had this discussion before. Go to court, ask the court that it is excessive. The court will reduce it. You don't lose anything. The only other thing you lose may be your application and your advocacy. So for me, I don't see this to be a big issue. That the one that worries me is to ask the AG why the courts are even giving those type of terms. The AG does not control the courts. The courts have their independent minds and their independent way of...
the AG who applies...
No.
The Supreme Court has said...
Is the AG...
The Supreme Court has said that bail is not ministerial.
Yes.
It is judicial.
Yes.
So if police inquiry bail, as EOCO, OSP, and Co are doing, they give you bail and you're not able to meet the terms, within 48 hours, are they not supposed to take you to a court for a court to determine your bail because you are not free? The law says you have to be released
within 48 hours.
Either unconditionally or on a condition.
See now, if you go to section 15 of Act 30, it says that the bond may be enforced as if it were a bond executed by order of court. So if the police or EOCO gives you bail with those conditions and you are not able to meet it, it is as if the court has given you those conditions and the same way they will enforce it. So it is not a matter of they've given you bail, you've not